Hello there and welcome. Thank you so much for tuning into the show today, Disability Law Show. I'm John Scholes. Beside me, Sivan Tumarkin, co-founding partner of Samfiru Tumarkin LLP. That would be the most positively reviewed disability law firm in the country, coast to coast to coast, helping thousands get the compensation they deserve, they are owed. So don't feel bashful. Don't hesitate to reach out anytime to just have a simple chat with Sivan or a member of his team. He'll hook you up big time. Here's the number, 1-855-821 5900, help@disabilityrights.ca. Another website you can go to, free information for you to ask questions. It's searchable. Maybe your question has been asked by someone wondering the same thing, right? mydisabilityquestions.com. Lots to get through in the show today, Sivan, including 3 ways to properly react to an LTD denial. There was 4, but it's a family show, so we're going to stick to 3, the safe ones. We'll get to that here in just a bit. But we always start the show with something you've been working on among your the colleagues and team in your office. It's the week that was, pal. What do you got going on this week?
John, I want to start off with an interesting call that I had this week from actually a family doctor out of Vancouver, actually, just the outskirts of Vancouver. Of course, we have offices in Ontario, in BC, and Alberta, and we help people with their long-term disability claims, fight their insurance companies when their insurance companies do things that are wrong, like cut them off prematurely or deny their claims, and ask them to do things they should not be doing. So that's what we do here. We're lawyers, and we help people deal with their insurance companies and their insurance claims. So this lady, 48-year-old general practitioner. She's a family doctor herself. She lost her husband. This was about 2 years ago. So she's a widow. She's got 2 young kids. And she has a private LTD policy, long-term disability policy. It's called a professional series policy. And this particular policy allows her to collect long-term disability payments until the age of 65 if she cannot work in her own occupation the entire time. Now, we're going to break that up a bit because usually when you and I talk about these things, John, we talk about, qualifying for LTD for the first 2 years. You have to demonstrate with the help of your doctors that you cannot do the essential tasks of your own occupation. And beyond the 2-year mark, it's any occupation for which you're suited for education, training, education, or experience. But there are some policies out there that have certain riders, and they're called own occupation riders. And this is what this lady did years ago. She got this private policy that basically says that if she's unable to work, she's disabled from working for any reason, and she is on LTD, she gets to be on LTD so long as she can show that she cannot be a family doctor in her own occupation, essentially, until the age of 65. This is very key, very important here. Why? Because she's been on LTD for about 1.5 years, almost 2 years. The insurance company has now said, and by the way, it's because of mental illness now, depression and all that kind of stuff that stemmed from her husband's death. So the insurance company has cut her off now, and they cut her off because they say that they believe that she can do something else. She can work in a different occupation. And so now you understand why I mentioned at the beginning that she has an own occupation rider. In other words, her type of LTD policy is not the standard one. It's the one that basically says, like I said before, that if she cannot be or work in her own occupation until age 65, she gets paid until age 65 or until such time that she no longer qualifies. Yeah. The test is not, can she do some other job? Can she do some other occupation? The test is she disabled from performing the essential tasks of her own occupation as a family doctor? And again, she's been told now that at the 2-year mark, she'll be cut off. So the adjuster that's dealing with her claim simply doesn't understand the policy that she has, is not reading it correctly. And she tried to clarify that with the adjuster. The adjuster's not listening. So I told her not to worry about a thing. We'll get in there. We'll help her. We'll probably end up resolving this case, in my estimation, probably within a matter of weeks of our involvement. Because as soon as I get a defense lawyer appointed over there, because I'm going to start a legal claim against the insurance company, the defense lawyer is going to explain to the insurance company that they have no leg to stand on. And John, this is something key to understand. Many people who come to us because they're experiencing mental health issues, depression, anxiety, phobias, all that kind of stuff. I'm not diminishing illnesses or injuries that are more physical in nature. I'm simply saying that with mental health illness, dealing with an insurance company is an added pressure, and it creates so much more anxiety, so much more depression, that oftentimes when I speak with people and I tell them I can help, and guess what? I'll be taking over everything to do with the insurance company. You don't have to talk to them. You don't have to deal with them. I'll deal with everything. My team will deal with everything. That's what they actually get attracted to, not the fact that I tell them that I can force the insurance company to pay them what they're owed. It's that you're going to be dealing with them. I don't have to take the phone call from this adjuster. I don't have to get an email anymore. And I tell them, yes, this is all part of the package. When we get involved, we are there. We are the ones the insurance company has to communicate with. We're going to push back. So with this doctor here, doctors are not, superheroes. They're respected, they're knowledgeable, they're professional, but they're human beings. And this lady here should not have been treated the way she has by her insurance company, but we're going to fix that now.
So with this lady's particular policy, so it's a little different. She's got the own occupation rider right up until she's 65. To keep that active on her side, is it just as simple as going to her doctor, getting an update saying, nope, she still cannot do her own job, therefore you still need to pay? It's all based on your medical examinations going forward?
Exactly what it is. She has a psychiatrist and a psychologist. Of course, she has her own family doctor. And look, she speaks the lingo. She understands what she has. I can tell you the reports I've read are very supportive of her being off work. No one is saying that she needs to be off work till age 65. But at this point in time, she's not ready to go back. And yes, she's approaching the 2-year mark. And if this was a standard policy, then we can have that discussion. Can she do some other job that will pay her 65, 66% of her pre-disability income, commensurate income? But that's not the policy she has. She doesn't have a standard policy. She has a professional series policies. You see those with a lot of professionals, doctors, lawyers, architects, engineers, management type individuals. And again, that's not to say that if she was herself not a professional and had a standard policy, it's not to say that she wouldn't have a case. It's just that this is so clear cut. It's a situation where you have an adjuster who simply does not understand what they're doing. Frankly, in a case like this, they should have assigned a more senior adjuster, but that's okay. We're going to rectify that. We're going to fix that. And it's a good thing that this lady contacted us, because I can tell you some people just walk away from a lot of money that's owed to them.
Based on you mentioned she's got a bit of a different policy. So for, the rest of the common serf like us that would have a standard policy, just quickly, I know we got to move on, but quickly just break down the difference between when it goes from the ONOC to the any occupation. How does that work quickly?
Absolutely, because that comes up all the time. Yep. Standard policies, standard LTD policies that you have usually through your employer or even sometimes privately. To qualify for long-term disability payments for the first 2 years, you have to demonstrate with the help of your doctors or whoever's treating you that you cannot perform the essential tasks of your own occupation. It's called the own occupation test, okay? That's what total disability under the policy means. Your own occupation, you cannot do it. Beyond the 2-year mark, under most of these policies, the test changes. The qualification for LTD is no longer can you perform the essential tasks of your own occupation. They now become can you perform the essential tasks of any occupation for which you are suited for by training, education, or experience. So most people ask me, what does that mean? Well, a good rule of thumb is look at commensurate income. When you get LTD, typically most LTD policies pay about 2/3 of your pre-disability income, 66% or so of your income before you became disabled. If you can find a job at that 2-year mark that will pay you approximately that amount or more, chances are the insurance company may have grounds to stop your benefits at that point. If you have that standard policy that has that any occupation test that gets triggered at the 2-year mark. So that's what that means, John. And by the way, if people go to our website, ltdfaq.ca, again, ltdfaq.ca, we have short memos for the public that deals with those kinds of issues and questions for free. You can just go there, browse, and you'll see that information and much, much more.
Another option for you anytime when we're not doing the show, pocketemploymentlawyer.ca. Now, of course, the other half of Sivan's firm is employment law because there's so much interplay. They're intertwined so tightly generally. So pocketemploymentlawyer.ca is an employment law-based website, but there is a section on disability law there as well, right, Sivan?
Absolutely, yes. Many people obviously are hungry for information about their employment rights, but also about their disability rights. And John, sometimes people don't want to call us for whatever reason. They don't feel comfortable. They just don't want to. They want to get quick information, so they'll Google it. Well, the problem is that you're going to get a lot of false information if you Google this stuff. And so we created the Pocket Employment Lawyer, that website that's free, it's anonymous, and it allows you to get quick answers, accurate answers to your employment law questions about your situation, your specific situation, as well as about your disability issues. And many times we see, John, and you mentioned that you have people who have issues with their employment at the same time they have issues with their disability claims or vice versa. And so that's why if you're having any issues with your long-term disability, you don't want to call us for any reason, go to Pocket Employment Lawyer, check it out. Just enter a few pieces of information about your scenario, not your contact info, but just about your scenario, and then you'll get quick and accurate answers about what your rights are. It's that simple.
I want to slide in a quick email, Sivan, before we take our first break. Again, help@disabilityrights.ca for you anytime you want to send us an email. You might get it on the show. This one from Frederick says, the insurance company just rejected my appeal of their decision to deny my LTD claim, even after I provided medical notes about my ailment from a second physician. They've offered me the opportunity to file a second appeal. Is it worth another shot?
The answer is absolutely not. Now, two mistakes that this gentleman has made, John, and these are common mistakes. I'm not blaming him. It's just something we see over and over. First one is believing that the insurance company will actually take this appeal seriously. Okay? They won't. They simply won't. I know they're going to disagree with me. I'm talking anecdotally here from experience. I've still, and by the way, you correct me here if I'm wrong, John, but for years I've been asking on this show, on our radio shows, for insurance companies to provide statistics about how many of these appeals actually are successful. I guarantee you, it's not going to be a nice number for the insurance companies. Because, look, when you're appealing a long-term disability denial, who do you think is actually reviewing that appeal? That same insurance company that denied you in the first place. So at the end of the day, you're appealing to the exact same people who said no the first time. Why would they say no a second time? The second mistake this person is making is having any faith that the insurance company can be objective about this kind of stuff. Remember, you're asking the insurance company to give you their money. Well, really, it's your money, but you're asking them to part ways with potentially tens, if not hundreds of thousands of dollars that's owed to you. Why would they, if there's any chance that they can deny your claim over and over and over, frustrate you, and then keep that money so they can utilize it whichever way they see fit? You know, I mean, that's their model, really, at the end of the day. It's just to make money. And one of the ways to make money is to deny claims. That's what they do. They do this day in and they do it day out. And so with this gentleman, John, I can tell you, there's no question in my mind that we can help him. I've dealt with many claims of this nature. So long as a person is disabled from working and they have coverage, LTD coverage, and they have a doctor, a treatment provider, someone that can provide support to the fact that they are in fact disabled from working, and here's why. Okay, not just saying on a notepad, this person is sick from work. No, I need more meat on the bones. Okay, we need to understand what is a disability and how does it functionally prevent the person from actually carrying out his or her duties. And if we have that, there's no reason for the insurance company to deny the claim, and we can force them to pay.
Coming up after a short break, 3 ways to react to an LTD denial, but we got to take a break first, so I'll give you a number as we get into that break. 1-855-821-5900 to reach out to Sivan and his team anytime, and that email address, help@disabilityrights.ca. We'll continue. More disability law shows on the way. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Disability Law Show. John Scholes here and co-founding partner Samfiru Tumarkin LLP, the most positively reviewed disability law firm in the country, practicing out of Ontario and BC and Alberta. Sivan Tumarkin alongside as well. Want to get into this topic, and it kind of dovetails nicely to the last email we just had before the break, Sivan. That is 3 ways to properly react to an LTD denial. Number 1, do not assume that the insurance company is right, that they're correct.
No, do not assume that. In fact, I will tell you, John, most often when I've seen those kinds of cases, I mean, I'm biased a bit because people who contact me feel very strongly that they've been wronged, but you should absolutely challenge the insurance company. Ask them exactly what is the basis for their denial. Oftentimes, when they deny a claim, they will provide you with a letter, an email, something in writing that explains why it is that they believe that you are not getting LTD, why you don't qualify. And I've seen denial letters that have, I think, close to 15 reasons for why they deny the person's LTD benefits. And I can tell you that case with the almost 15 reasons, we end up resolving that claim for over $300,000 6 months later. In other words, the insurance company said, here are 15 reasons or almost 15 reasons why we're not going to pay you a cent. Came to us, we went through everything. It was all nonsense. We basically started the legal claim. We pushed hard on the insurance company. We did what we had to do. 6 months later, we were at a mediation, resolved the claim for over $300,000. A lot of money owed to our client that our client received. So the first thing you do when you get a denial from an LTD insurer, the first thing you do is you give us a call. You email us because we can tell you very quickly over the phone. I would tell you within minutes if you have a case or not. And it's free. I mean, why would you not do that? Why would you simply take the insurance company's word for it? So the first thing you do is you look at that piece of paper or that email, you get my email address and you flip it to me, and I'll tell you very quickly. And by the way, once I tell you if you have a case or not, if you have no case, you have no case. But if you have a case, I'll tell you, here's what you can do about it, and then you decide. But at least you'll have the information. You'll be armed with this power of knowing if the insurance company is correct or not.
You know, it's funny you said you may be biased, but everybody should know if they don't. Well, they would if they've watched the show before or heard our radio shows, that you spent many years actually on the insurance side of things, so you know what's behind the curtain. But you left the dark side a long time ago. But I just thought I'd throw that out there. The second thing you need to know, Sivan, is this: don't let the insurance company pressure you into appealing the decision.
The A word, yes. Look, John, I don't know how many times I have to tell this to people, and oftentimes I get people who call me up who say, listen, I've seen your show many, many times, but I thought I would try it myself. And by the way, that happened a year ago or a year and a half ago, or sometimes more than 2 years ago, in which case we run into problems because there's a 2-year limitation period, right? But if you appeal that decision, you are doing exactly what the insurance company wants you to do, which is spin your wheels. You are a hamster on their wheel. It's that simple. These appeals are not external processes. They're internal, right? When an insurance company says to you, if you have any more documentation, any more reports from doctors, anything else you can give us, we'll review your decision, the decision to deny your benefits, and we'll get back to you. And they take their sweet time, and oftentimes it comes back with a big black on the paper, like text, no, denied. And that's what I'm saying, why waste your time with that? At the very least, know what your legal rights are. Look, talk to us. If at the end of that chat, we tell you have a case, and you say, you know what, I like what you told me, Sivan. I like what you told me, Samfiru Tumarkin, but I'm going to take my chances. I'm going to try it myself. Go ahead and do it, but at least you'll know where you stand. I can tell you, John, just from doing this for years and years and years, and my colleagues have been doing this for years and years and years, we've seen cases where people were rejected 2-3 times. And then they came to us, and as soon as we wrote a letter to the insurance company, suddenly they changed their tune because they understood who they're dealing with. So you have to be very careful of falling into their trap and going through this appeal nonsense, because it's going to end up nowhere.
Well, I think a lot of the time people that haven't, again, seen this show or listened to our radio show assume, A, the appeal process is mandatory. It's some big legal process they have to go through. And because it's an appeal, they think it's going to some tribunal or something outside the roof, the walls of the actual insurance company. Neither of those are true.
No, they're not true. There are cases where there are medical review boards. I will say that cases are different. But this idea of the insurance company saying, look, we're rejecting your claim. We are cutting you off benefits. And by the way, you can appeal this to us. It's just something that is very frustrating to individuals. They think that they have a shot, but it's rigged. It's just rigged, right? The insurance company, it's the same people making that decision if they're going to approve your appeal or not, or maybe somebody in the next cubicle. But it's the same company. So it is, you're betting against the house. I mean, you can do it, but I'm telling you, you're going to be frustrated and you're going to end up without money and you're going to feel like it's the end of the world, instead of simply coming to us and letting us help you fix the situation by pushing back on the insurance company with every legal tool we have.
Okay, we'll get to number 3. The third thing you need to do to react to an LTD denial, that is begin a legal claim within the appropriate amount of time, period of time. You did mention that kind of a few minutes ago.
I mentioned that because, again, going back to the earlier point of the appeals, we've had people who either appealed over and over and over until they ran out the limitations clock. I'll talk about that in a second. Or we have people who simply have been so traumatized by the denial and only years later either have heard of us or seen us on TV or heard us on the radio, and now they say, can you help me? And that was 10 years ago, 15 years ago. I've had those situations happen. And John, the reality is this. In Alberta, in BC, in Ontario, there is a 2-year limitation period for starting legal claims. When I say a legal claim, I mean that we are starting something that is above and beyond what the insurance company has control over. We are putting something in motion where if the insurance company ultimately doesn't come to the table, we will end up before a judge. But we rarely end up before a judge. Again, this is not American television. You are not going to go to trial, most likely. It's very, very unusual to go to trial or to go to a judge. Why? Because insurance companies understand that if they do that, they're taking a major, major risk. Not only can they be hammered by a judge, but they may be on the hook for their lawyers' legal fees and your legal fees. That's why these insurance companies are betting that you're not going to come to us or to lawyers like us. They're betting you're going to go through the appeal process. Or better yet, they're betting that you're going to walk away from the money that they owe you. So, you need to understand that there is a legal mechanism in place. Insurance companies are afraid of that mechanism because they understand that it's going to cost them more money, and they come to the table when we engage it and when we press them on it. And by the way, they have lawyers as well, right? You mentioned that insurance company. One thing that the insurance companies hate more than paying out claims is paying out their lawyers to defend these claims, only to have to pay these claims down the road anyways. When I used to work for insurance companies, years and years ago, many years ago, I remember the insurance companies, the adjusters complaining about my bills, not because it was outrageous, because they just simply hate paying their lawyers. Well, as soon as we start the process of a legal claim, they have to appoint a lawyer, either an external lawyer from a firm or an internal lawyer that they have on staff. Either way, it costs them money. So they are now bleeding money, and they need to stop that bleed. And the way to stop it is to come to the table and talk settlement.
MyDisabilityQuestions.com. I mentioned that earlier. That's a place for you to reach out and ask your questions. That is where we're going to go after a short break, which we're going to do now. And the phone number, anytime, 1-855-821-5900 as well. Disability Law Show continues. Stand by. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thank you so much for hanging in during that break. Disability Law Show is what we do every week. Sivan Tumarkin, of course, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed disability law firm in the land, practicing out of Ontario and BC and Vancouver. Phone number, 1-855-821-5900. But yet another way for you to reach out and ask your questions anonymously as well, MyDisabilityQuestions.com. Sivan, we'll get to Arlene. Arlene writes in and says, I was diagnosed with MS around the same time I started a new job. The first few years were fine, but now the intensity of the symptoms seem to be increasing and I can no longer perform my duties. I applied for LTD but was denied by my insurer. As they say, or as they believe, I am not quote-unquote totally disabled. How is this possible?
Well, Arlene, it's possible because this is what insurance companies do. But let me break this down for our viewers, John. This idea of total disability, when an insurance company says you're not totally disabled, they're referring to a term that they've invented. It's a term that is included in virtually every LTD policy, and it says, you are entitled to benefits if you are totally disabled. And here's how totally disabled or total disability is defined. And what you need to understand is that while to you and I and to the regular person, total disability just seems something catastrophic, right? You have to be catatonic. You have to be in such a state that you can't do anything, brain dead perhaps, or God forbid, have your limbs severed. No, that's not what total disability is. Total disability simply means that you are disabled or are unable to perform the essential tasks of your own occupation for the first 2 years, or the essential tasks of any occupation for which you are suited for by training, education, or experience beyond the 2-year mark. And so, Arlene, you have MS, multiple sclerosis, which is, a very difficult illness. And as a degenerative illness, it's something that I see all the time, people struggling with, that I did deal with long-term disability claims. And I can tell you that the vast majority of insurers understand the complexity and the difficulty that come with this illness, especially when it has to do with work, let alone home life. But sometimes you have insurance who don't fully understand that or appreciate that. And so they take the position, like they have with you, which is a preposterous position, that you are not totally disabled from your work, when you have doctors who are confirming that you are. Arlene, your case is going to be very easy to resolve. And I say easy, I don't mean that there's nothing to be done. I mean, we have to get involved and then start the legal process against the insurance company, but it's nothing you need to do on your end. And the reality is, this insurance company needs to get hit hard. And they need to get hit hard because it's such a preposterous position, as I said. John, something we see all the time, this idea that people get denied because they're not totally disabled or they don't fit the definition of total disability when their doctors clearly explain in letter format, on forms, on the application, LTD application, that this person is unable to work because of so-and-so. And people tend to think something is wrong with them. And I've even seen doctors who question themselves. In fact, I've seen doctors who tell their own patients, don't bother, we agree you can't work because of your illness or injury, but don't bother applying for LTD because you're not totally disabled. In other words, doctors themselves misinterpret what that phrase means. And that's important to understand. It doesn't mean what you think it means. Forget about the word total. The question is this: can you perform the essential tasks of your own occupation for the first 2 years, or any occupation for which you're suited for after 2 years? If the answer is no, and if your doctors agree that the answer is no, the LTD insurer must pay you.
I got to admit, though, that term totally disabled that was put forth by the insurance industry, man, it's a beauty. Whoever came up with that has just earned their pay, because how many people have been shaken off even thinking of putting a claim forward, just, I'm not totally disabled, I'm not quadriplegic, or I can't feed myself or brush my teeth or get out of bed. I forget it, I won't qualify. It's a brilliant term.
I have to tell you, John, I have been debating this with lawyers. I've even talked about this with defense lawyers who agree with me off the record that it's an unfair term. And insurance companies don't have to have that. They can simply say disabled. They don't have to say totally disabled. To me, it means that the insurance companies are trying to confuse the public and confuse medical professionals. I don't know if that was the original intent, but I can tell you that's what it seems like to me, and certainly that's the effect that I have seen.
Yeah, it's interesting. I know we got to go here in less than a minute, but we talked about the fact that if you're a piano player and somehow you burn your hands or you break them snow shoveling, you would qualify as totally disabled if you cannot do your job. It doesn't seem like it, but you would, right?
Yeah, because you cannot perform the essential tasks of your own occupation. Right. Absolutely. And the other thing is this, John. I tell people, if you have a question about this kind of stuff, that's when you contact us. Don't make the decision yourself. Don't go to somebody who does family law or tax law. We do disability work. That's what we do. Yeah. We know these policies inside and out. We deal with these insurance companies. We can help you navigate this, and it's all free. We don't charge you a dime for talking with you.
And we are done for another show. Appreciate you reaching out through emails and phone calls later on. And of course, mydisabilityquestions.com is where you want to go to ask those types of questions, or email help@disabilityrights.ca. And finally, the phone number, 1-855-821-5900. We'll catch you next time. Disability Law Show.